Justice is not a favor, it is a right. When the system forgets it, the court reminds them. In this video, we are going to see one such landmark judgment where the tax or revenue officer has acted beyond the powers given by the statutory provisions to them, wherein the court steps in and reminds them that they are not above the law, that law is supreme. In the case of Kaushlendra Kumar versus the state of Bihar, the taxpayer appellant has belatedly filed his GST 3B return pertaining to the financial year 2019-20. Of March 2020, GST 3B return is filed in the subsequent financial year of December 2021, wherein the proper officer has proposed to reject the claim of ITC amounting to rupees 50 lakhs approximately on the grounds that it has been hit by the time limit prescribed under section 16(4) of CGST Act 2017, according to which the time limit for claiming ITC for an invoice or a debit note pertaining to a particular financial year is the subsequent financial year November 30th or the date of filing of annual return, whichever is earlier. In the instant case, the taxpayer has claimed ITC beyond the time limit prescribed as per section 16(4) of CGST Act 2017. This is the facts of the case. But the taxpayer has his statutory right to file an appeal before the appellate tribunal against any such orders passed by the revenue. The adjudicating authority who passed the impugned order has initiated the recovery proceedings without giving time limit for filing or preferring appeal before the second appellate authority, which is the GST Appellate Tribunal. Section 78 of CGST Act clearly states that for initiating recovery proceedings, the time limit for filing appeal should be barred. In other words, whenever an impugned order, a demand order is being passed against a taxpayer or appellant, he has left with two options: either to file an appeal before the appellate authority or the next second appellate authority, GST Appellate Tribunal, or to accept the demand and pay the tax on demand along with interest and penalty. In the instant case, also the taxpayer has left with such two options. Also, the time limit of 3 months for preferring appeal from the date of passing of order is not yet fulfilled, before which the adjudicating authority has initiated the recovery proceedings from the taxpayer appellant by recovering rupees 50 lakhs amount. Within 28 days of passing of such order, being aggrieved by such recovery proceedings, the taxpayer has approached the Patna High Court that this is a clear violation of his statutory right. The Patna High Court has also categorically upheld that the act of recovery is clearly in violation of section 78. The act of initiative recovery proceedings is unlawful, and the court has quashed the order and directed the GST department to refund the amount which was being recovered along with interest at the rate of 6%. Also, the apology made by the officer that he has done a grave mistake, and which was also accepted by the Hon'ble High Court in this case. Stay tuned for such other interesting case laws with us. Thank you.